Bad lawyer jokes are an old genre, but if you're a consumer, finding a client-focused practice is serious. If you're an attorney, understanding today's ethical duty of care is critical. Anchored by current headlines and showcasing major legal minds, Ethical-ish speaks to consumers and attorneys about the modern, transparent law practice. Sponsored by Case Status, powered by LawPods.
Hello, everyone, and welcome to Ethical-ish. I am Paul Bamert. I'm part of the Case Status team and excited to be a sponsor of this podcast where we dive into some exciting topics, both for legal professionals and the everyday consumer out there. And I wear both hats, so I love these sessions. So today I'm excited to have a expert in many areas. Jeremy is joining us. Jeremy, say hello.
Hi there.
Awesome to have Jeremy Babener. We're going to get to know him a little bit and his expertise and where we sort of team up on this crossroads of ethics and technology and consumer and legal practices. So Jeremy, maybe to start right in, just a little bit of background of who you are and what kind of practice you're a part of.
Yeah, sure. I'm a tax lawyer by background, started in the Department of Justice and the Department of Treasury, the Office of Tax Policy, and I focus on advising plaintiffs and plaintiff lawyers around the country. Almost entirely, we're focused on tax strategies, different kinds of financial strategies, whether it's structured settlements, qualified settlement funds, plaintiff recovery trusts, the way that settlements are taxed and the way that we can reduce tax, take advantage of investment opportunities, and also the way that plaintiff firms are able to defer their fees, take advantage of subsidies. And then I've also kind of built my way in from being called in as an expert witness in legal malpractice cases involving plaintiffs and plaintiff work. We've also really focused on ethics issues and the ethical duties of plaintiff lawyers to spot issues outside of their expertise, tax, finance, and government benefits being kind of where we usually focus.
So very interesting space, to say the least. So you're telling me that even in a plaintiff settlement, that taxes rear their ugly head, death taxes and taxes, I guess.
Yes, they do, and including in cases that are entirely tax-free. There are significant opportunities for tax savings in the future that you want to be taking advantage of, as well as the tax subsidies. So we can get into that some.
Yeah. So, but from an ethical standpoint, I mean, federal government and maybe some state and local are going to get their taxes. So nothing ethical there, just sort of a pain in our sides as citizens. So let's talk about the ethical side of that. You say that you represent the other attorneys that are helping the everyday person out there. So maybe talk about some of the slippery slopes that maybe attorneys don't think about, or maybe that the clients that are hiring attorneys don't look for, with regards to their needing to bring in an expert like you into the conversation.
Yeah, sure. And actually, now that I think about the name Ethical-ish, we can talk about morality and public policy, and then we can talk about legal ethics and malpractice liability. On the kind of ethics and morality and public policy, like you said, the state is going to get their fair share. The real question, though, is Congress has enacted legislation that reduces taxation in a number of situations to do two things. One, when it's the right thing to do. And two, to incentivize certain actions. Like when you contribute to a 401k, you are being incentivized to do that. Congress wants you to save for the future, and they want plaintiffs to save for the future through what's called a structured settlement, to defer the time that they receive their payments. And they're incentivizing that with a tax subsidy. And they're incentivizing it because they want to make sure that that plaintiff is not taking all that money and spending it right away and ending up on Medicare or other government benefits. The problem and the reason why we often get involved is while a 401k is available and a structured settlement is available, and there's a lot of different tax strategies and ways that you can reduce tax, you have to check the box. You have to, dot your I's. You have to know what to do in order to take advantage of those benefits. And that's really where we focus our time. And a lot of the time, it's about the language that goes into the settlement agreement. And if you don't think about it, you sign the settlement agreement, and then you think about it, it's too late for a lot of those strategies. So that's the kind of the morality side. Certainly we are trying to make sure that plaintiffs and plaintiff lawyers are getting the benefits that are supposed to be available to them. on the legal malpractice side, you can imagine, anytime we're talking about the plaintiffs getting benefits, the lawyer's job in general, the plaintiff lawyer's job is to maximize what the defense is paying out. Where we focus is how do we make sure that we're maximizing the portion that the defendant's paying out that the plaintiff gets to keep. And can we increase the present value, the net value of that? And from the plaintiff lawyer's perspective, they want to increase that. That's just good service, good lawyering for their client. But a lot of times that good lawyering is kind of outside of their area of expertise. And in general, what the bar associations have kind of said is, well, for most plaintiffs, the plaintiff lawyer is the only lawyer the plaintiff will ever talk to. So you have some responsibilities to spot those issues, to flag those issues. You don't have to become a tax lawyer. You don't have to give advice on those issues. But when you're writing that settlement agreement, when the plaintiff lawyer is writing that settlement agreement, it's affecting the plaintiff's tax treatment. So there is a role there to be spotting those issues.
Yeah, no, it makes total sense. So I'm picturing the billboard that says, for the injury attorney out there is going to get me millions or has gotten millions. Now I'm looking at them differently. I want to know what their structured settlements are, what their net take home is, because you bring up a good point. If it's not actually thought through and planned, that can be a lot less. And I guess, if I'm the everyday person, the plaintiff in this situation, and I don't get that advice, and even if I don't go the path of malpractice to my attorney, right? I probably don't know enough to know that there may have been some malpractice in there. I still may not like my attorney very much after the settlement, like maybe give a bad review because I didn't really get to take home or I lost something. Do you see a connection between what I would call client satisfaction and the idea of not getting the most of what the settlement actually intended?
Yeah. So, there's the legal liability itself, and that doesn't come up a lot. It comes up quite a bit for me because I'm the one who gets called when something was missed. But I think in general, it's not coming up a lot. What really is coming up a lot is client satisfaction, and especially referrals. There is a lot of the good trial lawyers out there. They already have a relationship with a financial advisor, a settlement planner. There are several national settlement planning associations. I serve in leadership of the three or the legal committees, and their focus to their members is to train them on being able to spot, being able to take care of these issues. And so the trial lawyer will go to them just like they might go to an expert witness or an economist or someone to help them with the numbers. The effect is that what the plaintiff ends up putting in their pocket at the end of the day and keeping after fees, after taxes, after they've lost any government benefits, or if they're getting a bunch of government benefits or medical coverage, things like that, there is a significant increase in the value. There are many cases that we'll see where the value to the plaintiff is doubled because of a variety of arrangements or strategies. And you can imagine that ends up resulting in a whole lot more referrals, a lot more testimonials, a lot more word of mouth. And when trial lawyers are talking about this with their clients, often it can come up later in the conversation, but it gives the client something to focus on that is outside of just hammering the defense that results in their benefit. So there's a lot of different ways that this can improve the practice, improve the results of the work.
No, I love that. We talk about net promoter scores and measuring client satisfaction in our business constantly. It's part of our solution. And it's interesting because there are those who believe that even after you onboard, you shouldn't ask somebody what their satisfaction is, even though they may have gone through a full intake cycle. The follow along is there too, right? The case is closed, the settlement's there. Arguably, there's still this long tail of satisfaction that you want to make sure is delivered on. So you can do everything right from intake to case creation to case settlement, and still maybe not get that referral in the review. And I know Clio's Trends report oftentimes shows how the hiring decision is made. And you bring up a good point. It's reviews and referrals constantly checking against what the public sentiment is. So makes a big difference.
And there's also, it's what is being said, about a firm. It's, the first thing that someone wants to know about that plaintiff firm is, what are the verdicts? What are the settlement values? Are they effective at scaring the defense, convincing them to pay out? But that is one conversation. When you have several other things to say that are positive, the conversation continues. And so, for example, and this is just one of the arrangements, but one of the most common are structured settlements. And it's the ability to receive payments over time. If you receive a significant amount, that's a huge win. Now, if instead you're receiving a large portion of that and you're going to be getting that for the rest of your life, and so your future financial security is done, you're taken care of, that's a different kind of conversation that you have, and it's a different kind of testimonial that you end up providing. And when it comes to personal injury, someone gets injured, they talk to their friends, and someone's going to say, oh, you should go to the Bob Menendez firm down the road. It's about making sure that the people around you know who the right people are to go to.
Yeah, no, that storytelling definitely makes sense. So let's go back to, we've got both attorneys and everyday people hopefully tuning in to these podcasts. So to the attorneys out there that you've been called into, what's typically the rule of thumb that they leave that experience of? I assume they come back and work with you again. Are there sort of amounts of settlements to where they're like, structured settlement should be considered, it should be favored, it should be absolute? Do you have any numbers out there that you use?
So I'd say it's kind of different levels for different arrangements. I'd say, anytime that you're, over 100,000, there's going to be the basic settlement language issues, making sure that the language itself is preserving tax-free treatment, making sure that there's not something in there that's going to cause a portion to be taxable. You might start thinking about, well, even in a tax-free settlement, can we preserve our medical expense deductions in the future, things like that. Once you get over, maybe 300,000, now you're thinking about those same issues, but a lot more, because now they make a much bigger difference. A savings of 5% on a $5 million claim is very different than a savings of 5% on 100,000. How much time do you want to spend on it? What kind of cost are you going to invest in that? For structured settlements, which are, pretty common, I'd say somewhere around 250,000 and above is where it really makes sense. If you're over 500, 750,000, then you really should be considering it. If you're in a physical injury action, then you definitely want to be thinking about, if your client has a lot of medical expenses coming up, you want to be thinking about preserving that deductibility. If you're in a non-physical injury case, defamation, violation of different kind of rights, landlord-tenant cases, in those cases, you want to be thinking about the fact that most likely your damages are going to be taxable. So unfortunately, that means you're going to be hit by the plaintiff double tax. You're going to pay tax not just on the net, but also on the portion that is going to go to the attorney fees and costs. You can avoid that with the plaintiff recovery trust. So, if you're over 150,000, 250,000 in a taxable case, definitely want to be thinking about something like that. If the plaintiff or the attorney knows that the plaintiffs are going to need Medicare, Medicaid, we need to be thinking about preserving those government benefits. We're thinking about a Medicare set-aside account. We're thinking about a special needs trust. And, it just kind of keeps going from there. A little bit of it is ad hoc. When we work with plaintiff lawyers, usually the first time that we work through a settlement, there's a lot of things that got missed, and we're coming in right at the end and we'll say, hey, we can still get the vast majority of the value, but boy, if the next time you were to throw this in the complaint, we can do a little bit more. And so after that, you kind of get into a little bit of a flow where, anytime there's a case or anytime there's 5 cases, maybe on a monthly basis, you call and you have a discussion about, at a very high level, here's what's going on in the cases. And you spot, okay, here are the 2 cases where it's really worthwhile to dig in more and maybe we can make some changes. I'd say that's kind of the broad level. Anytime that you have someone on government benefits, though, you always want to be having a conversation about that, not just for the plaintiff, but also for the lawyers. Because if there's a Medicare lien, not only is the plaintiff potentially going to lose out, but the lawyers can actually be directly liable, even liable for treble damages. And so you want to make sure, if you're a plaintiff lawyer, make sure you're working with a settlement planner who has that kind of knowledge and can call in more specialized people.
Yeah, so it's way more than taxes. It sounds like that you've gotten into an advisory role that built on taxes, got into entitlements. I think you and I have even talked about things like, the plaintiff just out of necessity going out and setting up a GoFundMe page to help with bills. A big no-no, right? Like that's just something you don't do.
Yeah, absolutely. So GoFundMe, one of the things that is not discussed is when you start raising money, if you receive it directly, your problem isn't as much tax. Your problem is government benefits. Usually if you're raising money, you're probably on Medicaid. And so if Medicaid has an assets and an income test, and if all of a sudden you have more assets coming in, if you have more cash flow, you may lose those benefits. And we're aware of situations where that happened. And so early last year, we actually worked with a 501c3 charity that's been around for 4 decades. Their focus, it's called Help Hope Live. And their focus has been to help people raise money online using the charity. So the money goes into the charity, and the charity pays those medical expenses a lot like a special needs trust. What we did is we partnered with them. All of this is volunteer and on donation basis. So the entire board of the plaintiff fund committee is volunteering their time. And what they've done is they've kind of created a bit of a division of Help Hope Live so that any plaintiffs and plaintiff lawyers who are working with plaintiffs who know that they're going to ask their community, they would normally go on GoFundMe. Now they can create a page on the website to recruit and ask their church, their school, members of their community to donate. The donations will be tax deductible to the donors. It won't cause any loss of government benefits. And one of the things we've done is we've raised money so that every plaintiff who does this receives $1,000 toward their medical fundraising that they can start using right away. And so the plaintiff fund has been it's been around about 1.5 years now. Great resource, entirely free to plaintiffs to use. Feel free, it's plaintifffund.org. Feel free to reach out.
Yeah, very interesting. I mean, in the first case, it's sort of, I only hire one attorney, so I hope to get some advice on the tax side and the structured settlement, right? But here's a case where, as an attorney, a plaintiff attorney, you may want to be giving your folks who are on entitlements advice not to do certain things and maybe to do them a different way if they give you insight. So I think some really good best practice tips for our attorney audience out there listening in. Certainly, both can reflect poorly on your brand, not by anything directly per se, but it comes back to that referrals conversation. So and again, I think about ethical-ish. We talk a lot about the ABA model rules of professional engagement. A lot of this stuff is, not intentional to be, one way or the other, but one of the things we want to do is just give folks tips so that they can execute in the spirit of ABA in sort of a modern world. And these are, GoFundMe didn't exist 20 years ago, right? So it is a very interesting use case to discuss for sure. On the structured side, one more quick question before we'll close out. I'm just curious, when a settlement comes through, is there a structured side for the firm as well? Do they consider, this idea of, taxable income this year versus spreading it out and structuring that settlement in a particular way, especially if it's a certain size?
Yeah, definitely. So there's multiple options out there. There's annuity-based, market-based, and others. What is, for most plaintiff firms, income and revenue is kind of going up and down each year. And that can spike you into a really high tax bracket when you shouldn't be if it was leveled out. So plaintiff lawyers are able to use deferral in the same way that plaintiffs can use. And usually it's called a structured fee or a fee deferral. Often there's a little more flexibility, and this is true for a lot of things. Using a qualified settlement fund often means that the defense is not part of each of those transactions. The money goes into the qualified settlement fund. Now you have time to deal with liens. You have time to effect structured settlements, structured fees, and so forth. But that's certainly available to attorneys.
Yeah. How many attorneys do you think take advantage of that sort of strategy in their business to smooth things out, especially for the large settlements?
Yeah, I'd say the vast majority, or at least the majority, healthy majority of attorneys who are receiving large settlements on a regular basis, because, if you've done this a few times, you've learned of the opportunity. If you only have 1 or 2 large settlements, then, it's probably an opportunity that you might not be aware of. You really should ask about it. It is highly advantageous. For attorneys that are involved in more kind of the small, medium size, a great move is to talk with a financial advisor or a settlement planner and come up with structuring a small portion each time. And this is what you can do is you're kind of building up like monthly income for the next 30 years. And maybe it's a small amount of monthly income after the first few cases, but you can keep ratcheting up and complementing that. And over a period of several years, you end up with a stream of income for the next 30 years that's pretty sizable.
Yeah. And certainly for those lumpy settlements, I mean, our friend Ryan McKean, formerly of Connecticut Trial Firm, they had a $100 million settlement. And certainly those types of settlements can help out in the long run. So love to hear that both sides. It doesn't just go for the everyday plaintiff, but also for the firm as well. So a lot of good strategy built in here. CLEs, is this a CLE topic? Like what we're covering today? Does this get thrown out there in the sort of academic space?
I do. I mean, I offer a lot of CLEs. Okay. I'm presenting for a lot of the bar associations, trial lawyer associations, a lot of the financial advisories, some CPA organizations. We especially find ourselves talking about the ethics issues and malpractice issues. Everybody wants ethics CLEs, right?
Yeah.
So we're often there. I don't see a lot of other speakers on these topics, but we certainly are, and there are definitely a few others, especially on government benefits. There are several experts who I regularly see giving CLEs.
Well, it sounds like a good one. I'm sorry I don't have a secret word for everybody out there so that they can get their CLE credit here on this podcast. But if we can promote anything, it's that continuing education. Get out there, find those CLEs, and continue the discussion. So, Jeremy, close us out. I guess my closing question to you is, again, for our two audiences. So we'll start with the plaintiff attorney. If I took one of your CLE classes, or if I just had coffee with you, what's the big headline? What's the one or two things that every plaintiff attorney in your mind should put into action today and throughout the year to have a better and healthier practice?
I'd say having someone in your office who knows how to issue spot at the highest level these kinds of risks and opportunities. And that's usually what we focus on the first time we're working through a case with a plaintiff firm is there a paralegal? Is there a legal assistant where we can, we're having conversations about, boy, if a case involves these issues, you really want to have a larger conversation. The other would be forming a relationship, if you don't already have one, with a settlement planner who's not only focused on structured settlements, but is a holistic settlement planner. They can think about government benefits, they can think about tax, they can think about finance, finding ways for plaintiffs to be informed, whether it's through the next phase community or others where plaintiffs are going to have access to the information they need, or as a trial lawyer that your staff does.
Great. And the flip side, you're hanging out with a relative over the holidays and they say they need to hire an attorney. What advice do you give to that everyday person of the one or two questions to ask in the hiring process to make sure that attorney is the right attorney for you and thinking about these things?
I think asking, what issues beyond just maximizing that recovery are they spotting, and who do they work with that is kind of outside of their area of expertise, and on what subjects? If they're able to rattle off a couple names and a couple subjects, you don't know for sure, but that means that they're actively thinking about it. The other thing I'd say is, if it's anybody especially in kind of the finance community, to be able to ask them, hey, do you know of a trial lawyer that is thinking about these kinds of things? That's always a good start.
Yeah, no, it definitely makes sense. I mean, I don't want to analog a lot of these plaintiff decisions to playing the game show of Jeopardy, but you always think about the tax man or woman is out there waiting to collect, and you got to be smart about it.
And the thing is, tax shouldn't drive, right? You need the trial lawyer who's going to maximize the recovery. That's the number one. You don't get a recovery, I'm not going to be very helpful. I can't save taxes on $0. I'll guarantee you have $0 of tax.
Yeah, that's a terrible tax strategy, by the way. It's a tax strategy, but it's a terrible one.
Yeah. So, it's pretty rare that a tax strategy that we want to recommend is somehow going to interfere or get in the way with recovering a larger amount. But at all times, first things first, you maximize the recovery, then you maximize the amount of the recovery you get to keep.
Awesome. Well, Jeremy, we really appreciate you joining Ethicalish. It was a great discussion. I learned a lot. I love these sessions. And again, we'll keep a lookout for your firm and your practice and a lot of the topics that you've educated us on today. And for my audience out there, if you find Ethicalish to be of value, we ask that you simply subscribe or follow whatever platform you're using so that you can be informed of future episodes, which we're excited to be bringing your way. So until then, hopefully we will see you on the next episode. Have a great day and talk soon.
Thank you very much.
Lawyers and legal consumers, you are our audience and our biggest strength. If you find Ethicalish a good investment of your time, please spread the word. Until next time. Sponsored by Case Status, powered by LawPods.